Okay, well, I would like to welcome everyone to the Lane Lyceum. We're very excited to have Dr. Daniel Medwed come and share his expertise about the incarceration and the system that keeps people, in jail, even if they shouldn't be. And so Lane Lyceums have a long tradition in New England, not Lane Lyceums, Lyceums. And, and that's something, it was a place that people could share ideas and discuss them and debate them. And that's what we've tried to do with our Lane Lyceums, is to have a place where we can share important ideas. So that's what we're doing, and we're happy to be able to continue that tonight. I would ask everyone to please mute. I think most people are, but if everybody would mute. And also, there are a few people that might not be on our mailing list, our email list. And so if you would like to be notified of other Lane Lyceums, please just put your email address in the chat, and I will just add you to the list. We have a number of wonderful programs coming up in the next several months. So I will now turn it over to Neil Elper, who will introduce Dr. Medwed.
Thank you very much, Amy. I'm going to read it. It's a bit formal in the introduction, but while Daniel and I were on the faculty at Northeastern at the same time, I did not know him, so I'm going to be a little bit more formal, Daniel. Professor Daniel Medwed is University Distinguished Professor of Law and Criminal Justice at Northeastern University. He is a leading authority on criminal law, focusing on the topic of wrongful convictions. Tonight, he will be discussing his book, Barred: Why the Innocent Can't Get Out of Prison, that explores the range of procedural barriers that prevent innocent prisoners from obtaining exoneration. Professor Medwed is a founding member of the board of directors of the Innocence Network, a consortium of innocence projects throughout the world. He currently serves on the board of the New England Innocence Project, and you may also know him as the legal analyst for GBH News, especially on Morning Edition with Paris and Jeremy. I've heard him on that a number of times. Prior to Northeastern, he was a professor of law at the University of Utah. He served as an instructor at Brooklyn Law School, where he helped oversee the school's Second Look program, in which students investigated and litigated innocence claims by New York State prisoners. He also worked in private practice and as an associate appellate counsel at the Legal Aid Society Criminal Appellates Bureau of New York City. He earned his BA in history at Yale and his JD at Harvard. So and the title of Professor Medwed's talk will be Talking Technicalities in the Realm of Criminal Justice. Daniel, the floor is all yours.
Thank you so much, Neil and Amy, both of you, for inviting me and sharing a bit off screen about the Lyceum and about your wonderful church. And it's just an honor to be here. So as Neil suggested, I'm going to talk about an area of criminal law that is underexposed, in my view, which is, we all know it's pretty easy to convict an innocent person. You've seen the movies, you've read the stories. What's less well known is how darn hard it is to free them on the back end. Okay, so when thinking about why an innocent person gets convicted in the first place, we now have over 30 years of documented DNA exonerations, cases where people were convicted of crimes they didn't commit, and they were freed, exonerated after their convictions when biological evidence from the crime scene was tested and excluded them as a perpetrator. Many of these cases are 100% absolute clear cases of innocence. A single perpetrator rape case where the rape kit was later tested for biological evidence and it came back as a match to someone else, right? Cases like that. And so we've deconstructed what went wrong in those cases. So let's just start with some of the things. We know that eyewitness misidentification is a big factor. We know that shoddy defense lawyering is a big factor. We know that prosecutorial misconduct and police misconduct, big factor. We know the use of jailhouse informants, the use of flawed forensic evidence. These are all big factors. But what we don't know as much about, and which has animated this discussion tonight and will animate, and has animated the book I published in September called Barred, is while we know a lot about how we convict the innocent on the front end, we don't know as much about the process and the vehicles for freeing them on the back end. And what we do know is really, really alarming. Okay, so what I'll do now is just sort of lay the table, give you the framework for how people can claim innocence after trial. And then I'll give you a story from my own experience. As Neil mentioned, I'm a law professor, but before becoming a law professor, I was a public defender in New York, representing indigent clients on appeal of their cases. And I also ran an Innocence Project at Brooklyn Law School, where we would investigate claims of innocence by New York State prisoners. And I'll tell you a war story of one of my clients. So in terms of setting the table, the trial, as the US Supreme Court has often said, is considered the main event in our criminal justice system. You have the presumption of innocence, and once you're convicted after trial, the presumption flips, and now there's a presumption of guilt. The trial is mentioned twice in our US Constitution. Believe it or not, there is no reference to an appeal. You are not constitutionally guaranteed a right to appeal your conviction in the Constitution. Every state gives you that right as a matter of statute, as a matter of law. And if a state didn't give you a right to appeal your conviction, it might be a problem. It would be what's called a due process problem. You're not given enough due process before the government takes away your liberty. However, the direct appeal is a bad vehicle for challenging your innocence. And here's why. The direct appeal is what's known as a vertical attack. It's a direct attack on what happened at trial. You are forbidden from introducing new evidence at all. You are constrained by the trial record, and you can only challenge issues that were raised before the trial judge. What's more, to add insult to injury, the only issues that you really can challenge on appeal were not only raised to the judge, but were what's called preserved. They were adequately discussed and argued and debated on the record. The idea is it's efficient to bring all of the legal issues to the judge's attention early on because the judge might get it right, and it's much more efficient that way. The downside is that if a judge gets it wrong and you lose at trial, the direct appeal is not a way to overturn it. It's a way to challenge legal errors or to claim that a judge didn't let evidence in that she should have let in. But it's not generally a way to challenge the guilt of the person. So what other options are available? Here are the other options, and then I'll put it all together for you. There's the great writ of habeas corpus, which some of you are probably familiar with. It's in our Constitution, and the Constitution says that the writ of habeas corpus may only be suspended in times of war or rebellion. What is the great writ? We inherited it from ye olde England. Habeas corpus means show me the body. And basically, it's a way to force the government to justify why they have someone in detention. As someone who's in detention, you could file a writ of habeas corpus at the front end before you've been tried. This is what happened in the famous Guantanamo Bay cases, where we've held, and to this day, we still hold people in long-term detention at a base outside Cuba without ever charging them with crimes. And sometimes lawyers acting pro bono on behalf of those detainees will file habeas corpus petitions saying, government, tell us why you have this person in custody, justify why you have the body. But more often, and for my purposes, what's interesting is that you can use habeas corpus as a way to challenge a conviction for a prisoner who's already gone to trial. However, and here's the rub, like the direct appeal, habeas corpus, which isn't a vertical remedy, you attack the case from the side, and you can bring in lots of new evidence if you have it. It is also not a good way to challenge innocence or guilt, because the traditional view of habeas corpus was that it was a vehicle to challenge constitutional or jurisdictional issues. In 1993, the US Supreme Court, in a very, very controversial decision called Herrera versus Collins, said quite emphatically, a freestanding claim of actual innocence is not recognizable in a habeas claim. You have to introduce a constitutional claim or a jurisdictional claim. Factual questions of guilt or innocence, that's for the trial. Or maybe for a judge on clemency, a governor or a president to consider in whether to pardon someone. So habeas corpus doesn't work. The first two remedies I mentioned don't really work. Here's the third, and this one, maybe you'll be getting your money's worth. And since you haven't paid for this, I assume, I hope you get your money's worth. This third option is called the writ of error coram nobis. And I bet, unless there are lawyers here, no one has probably heard of it. The writ of error coram nobis, it derives from 16th century England. And coram nobis means before us. And it's a way to go back to the original trial judge with newly discovered evidence that casts doubt on the conviction. You go back to the original judge and you say to her, look, I have compiled all of this new evidence after my conviction. It casts doubt on my guilt. I should get a new trial. So it really is, in theory, the perfect vehicle to attack an innocence case. However, in practice, it is not, because judges tend to interpret that phrase newly discovered evidence very narrowly. Oftentimes, judges will say, if the evidence is newly available, that's not enough. If it could have been discovered at the time of trial by someone, then it doesn't count as newly discovered. And then you're between a rock and a hard place. Well, you say, okay, it doesn't count as newly discovered. The trial lawyer could have found it before trial, so maybe it was ineffective of the trial lawyer not to find it. And surely we can win on the grounds of ineffective performance of the defense lawyer. But then judges will sometimes, you're whipsawed. They'll say, well, it wasn't really egregious of the defense lawyer not to find it. So you're sometimes in between these two positions. It's neither newly discovered evidence nor ineffective assistance for failing to find it, okay? So that does leave executive clemency, which in that Herrera case I mentioned, the habeas corpus case, the Supreme Court cited as a fail-safe. If the trial doesn't get it right, and we can't address this in the court system, executive clemency is the traditional vehicle for freeing the innocent. And Chief Justice Rehnquist said, history is replete with examples of governors and presidents and pardon boards freeing the innocent. But that's just wrong. Chief Justice Rehnquist vastly overstated the extent to which clemency acts as a guardrail. The whole premise behind clemency, behind getting the government to pardon you, and for Unitarians, I bet this resonates, it's all about mercy and forgiveness. We forgive what you've done, and we believe you deserve a clean slate. And a prerequisite to forgiveness, to mercy, is repenting, or to some extent, expressing remorse for what you've done. That's the first step on the path toward forgiveness, right? It's not just Unitarians, but everyone, every faith has some form of this, right? That the first step to forgiveness is admitting error and expressing remorse and accepting responsibility. Now, how could an innocent person accept responsibility for something they didn't do? It's just counterintuitive. So pardons are usually designed for people who committed the crime, and they've made tremendous strides towards self-improvement during their incarceration. They've become rehabilitated, they're changed people. So basically, none of these procedures work. And the gist of my book, the whole thrust of the book, is that this is a tragedy. And this is something that we all should work on and be aware of, that it's easier to convict the innocent than it is to free them. Okay, in my remaining few minutes before I open things up for questions, let me just put this all together in a war story. I assume many of you have been to Suffolk County. I mean, Suffolk County, New York, the real Suffolk County. Some of you have probably been to Suffolk County. For those of you who've been to Suffolk County, New York, it's Long Island. And the Suffolk County that I'm talking about is not Southampton or Bridgehampton or one of those nice parts of Suffolk County, but it's a town called Brentwood, which my strong hunch is that many of you are unfamiliar with this town. It's near Riverhead, which is the county seat. So here's the story. At 8:20 p.m. on February 3rd, 1999, a large white man went into a restaurant at a strip mall in Long Island, go figure, a strip mall in Long Island, and he ordered a shrimp dinner. It was not a popular restaurant. The only other people in the restaurant were a waitress and the cook. While the cook was preparing the shrimp dinner out back, the man withdrew a knife, put it to the throat of the waitress, and asked for her to turn over money from the cash register. She complied, gave him $32 in change. She screamed, the perpetrator fled, and the cook came out of the kitchen. Both the cook and the waitress caught a glimpse of the man as he left in a late model white car with New York plates with a T and a 1 in the license plate, okay? So here's what we know. Large, heavyset white man, mid-30s, robs a restaurant, flees in a late model white car with a T and a 1. Police are called, they come down to the scene, they show both the waitress and the cook what's called a 6-pack. 6 photos of large white men in their mid-30s who basically resemble this description. These photos are basically culled from arrest records in the county. Independently, both the cook and the waitress identify a local man named Stephen Schultz as the perpetrator. Now, Stephen fit the bill in a couple important respects. He was 6'2", 250 pounds, and 35 years old or so. He also had a lengthy criminal record. However, he did not fit the bill in perhaps the most important regard. None of his crimes involved acts of violence. They all involved petty theft or things related to drug addiction. Not a single incident with a knife or a gun, nothing to do with violence, okay? The police pick up Stephen. He says that he was home with his roommate watching television at 8:20 p.m. on February 3rd. They were watching the ABC sitcom Dharma and Greg. Have any of you remember that show, Dharma and Greg? It was on for a few seasons around then. Now, for those of you who remember that show, would anybody willingly say that they watched that show unless it were true? I mean, it's not a good show, right? It's kind of embarrassing to admit, like, you have nothing better than to watch Dharma and Greg on a February night. But the police arrest him, and he's charged with first-degree robbery. He's charged with first-degree robbery. He's facing in excess of 10 years in prison if convicted. He's too poor to pay for a lawyer, so he's assigned a public defender who will be nameless, Barry. And Barry takes on his case, and Stephen can't make bail. So he's waiting in the Suffolk County jail. He's waiting for trial, and he reads the local newspaper, Newsday, and he reads the following article. I'm paraphrasing. Large white man pleads guilty to 6 robberies. Another man whose picture was in the newspaper, named Anthony Guilfoyle, had just pled guilty to 6 factually analogous storefront robberies in the Brentwood vicinity from January to March 1999. His method of operation, his MO, was to use his bulk and the threat of violence to intimidate people into getting money out of their registers and handing it over, their cash registers. Stephen reads this article. He calls his sister. He tells his sister to call his lawyer because his lawyer won't pick up his phones from the jail because his lawyer doesn't want to pay to collect calls, presumably. So Linda, his sister, calls the lawyer and says, Barry, investigate my brother's case. This other guy pled guilty to 6 crimes, and my brother was home watching Dharma and Greg with his roommate. Barry's too busy. He says, let's see what happens at trial. I don't have time to investigate this. Here's what happened at trial. Stephen was offered a plea bargain of 3 years in prison. With his lengthy criminal record and the prospect of facing in excess of 10, that was a pretty good deal. He said, no, I'm innocent. I'm not going to plead guilty to a crime I didn't commit. I'd rather go to trial and lose and face 10 years than to say I'm guilty for something I didn't do. So case goes to trial. Here's what happens. The cook gets up on the stand, looks at Stephen Schultz and says, that's the guy. That's the guy who committed the robbery. I remember it. It later turns out that this cook had his own pending gun possession charge that disappeared in the aftermath of his testimony against Stephen. Then the waitress takes the stand. And I know you guys are deep thinkers, so you probably don't watch bad TV like I do. But if you have watched bad TV, at this moment in a crime drama, the crime victim's taking the stand. Usually one of two things happen, right? It's a empowered victim moment where the crime victim points a bold finger at the defendant and says, that's the guy. I'll never forget his face. Or it's the scared victim moment where a wobbly finger reluctantly points out the defendant and says, that's the guy. I can barely look at him. But in this case, a third thing happened, something I've never seen, and I'm curious if any of you have. The victim, the waitress, looks at him and she says, wow, now that I see him in the flesh as opposed to a picture, he's not the guy. The guy who did it was taller and heavier. Well, guess what? Anthony Guilfoyle, the man depicted in Newsday, the man who pled guilty to 6 factually analogous storefront robberies, was 6'4" and 350 pounds, 2 inches taller, 100 pounds heavier than Stephen Schultz. Stephen pulls on the suit jacket of his lawyer. I have this vision. I'm making this part up, but I have this vision. Do something, Barry. Do something. Barry, the lawyer, has the picture of this other man, Anthony Guilfoyle. He has a couple options. He never interviewed the waitress beforehand. He never investigated this case. And an axiom of cross-examining somebody is you should never ask a question you don't know the answer to. What if she says, that's not the guy either? What are the odds of 3 heavyset 30-something white guys running amok in this tiny little not so great town committing this very idiosyncratic type of robbery? So he does the best that he can do under the circumstances, but certainly not the best he could do. He tries to get the photograph into evidence for the jury to consider for itself whether a mistake might have been made. That here's this other guy who committed robberies. Maybe there's reasonable doubt. Maybe there's a misidentification. But under the rules of evidence, the judge, Judge John Copertino, under the rules at the time, he refused to let the photograph go to the jury because you had to show that there was a clear link between a third-party suspect and this particular crime. It's not enough to just present circumstantial evidence that he had committed similar crimes. You had to show some connection to this robbery. And Barry didn't have any evidence that he was even in the vicinity of this restaurant on February 3rd, 1999. Stephen's convicted based on the cook and not the waitress, and he's sentenced to 11 years in prison. Nearly 4 times what he was facing had he accepted the plea. He writes to me at Brooklyn Law School. I didn't have gray hair then. And I was the junior person on a 2-person team, meaning I did all the work and got none of the credit, where we would investigate and litigate claims of innocence by New York State prisoners. It was called the Second Look program at Brooklyn Law School. Neil is an academic. You can appreciate it. I was an instructor on contract. I didn't yet have a tenure track job. And he asked us to take on his case. And because we were just starting out our clinic, we had the bandwidth for it. So I said yes. So here's what we did. We agreed to represent him on the appeal, and we agreed to also investigate the case for other post-conviction remedies. So here's what we did. We filed that direct appeal, the direct remedy, but we were limited to the issues that were raised at trial. There's no new evidence, nothing off the record. Our only good claim is that the judge should have introduced that photograph. In the interest of justice, the judge should have let the jury figure out whether this other guy, Anthony Guilfoyle, could have been mistaken for Stephen Schultz. But the appellate court, because of the rules of appellate procedure, gave tremendous deference to that trial judge and said that the trial judge didn't abuse his discretion in refusing to let in the photo. So the conviction was affirmed on appeal. So we began to investigate the case. with an eye toward a New York State coram nobis procedure, right? That remedy I mentioned before, where you get to go back to the original trial judge with new evidence that casts doubt on the integrity of a verdict and try to get a new trial. So we investigated the case from soup to nuts. Here's what we found. We found the roommate, the alibi witness, found him to be really credible. He was a disabled mechanic with no criminal record. And he signed an affidavit under penalties of perjury saying they were watching Dharma and Greg at that particular time. This was a pre-streaming era, and we looked at good old TV Guide to verify that that particular episode was airing on that particular time at the ABC affiliate in Suffolk County, New York. Then we found the waitress, who was very difficult to locate because she was in this country without proper documentation and didn't want to be found. We did locate her. I showed her, my students and I showed her photographs of both our client, Stephen Schultz, and this other man, Anthony Guilfoyle. We showed her both pictures together, and she pointed to the Anthony Guilfoyle picture and said, I'm 90% sure that that's the guy who did it. She then signed an affidavit under penalties of perjury, saying that she was 90% certain that the man who robbed her on February 3rd, 1999 was not Stephen Schultz, but this guy, Anthony Guilfoyle. Then in the pièce de resistance, my much more tech-savvy students somehow got access to state motor vehicle records in New York. Didn't find anything with respect to Anthony Guilfoyle driving a car, but they found out that his wife, Kim Guilfoyle, at this time had a car registered to her, a white Oldsmobile with New York plates, with a T and a 1 in the license plate. We compiled all of this evidence and we submitted it to the original trial judge, that Judge John Coppertino. And my student and I drove to Riverhead, New York from Brooklyn to simply try to convince him to have a hearing on our evidence, to just let us put the waitress, the alibi witness, through their paces in open court. And if he found this evidence important, then maybe as a next step, he would order a new trial. We're 4 steps removed from freeing this man. I am just asking for a hearing that could be used to get a new trial that could be used to acquit an innocent man, okay? I show up and I'm interrupted right away by Judge John Coppertino, who I later learned had the nickname Crappertino in the halls of this. Am I allowed to say that in front of Unitarians? I suspect I am. And he said, your client is not innocent. I remember this case. The waitress was scared of him. That's why she didn't identify him. He denied us even a hearing. We did not even have an opportunity to put the waitress on the stand, the alibi witness on the stand, to simply show whether we had a right to get a new trial in a case where this mountain of new evidence suggested our guy was innocent. Then we appealed that decision all the way up the New York courts. And because of the rules of appellate procedure, the deference to the lower courts, the judges said the decision to deny the evidentiary hearing through coram nobis was not an abuse of discretion, decision affirmed. Ultimately, we got to the highest court in New York, the equivalent of the state Supreme Court, and only a single judge agreed with us. The majority of judges agreed and affirmed the decision not to give us an evidentiary hearing. And the single judge, Judge Rosenblatt, I'd like to say his name because he's a little bit of a hero, he said, you know, something's wrong with a system that doesn't give us the capacity to vet this type of evidence in open court. We should hear what the waitress has to say based on this new evidence. And if our procedures don't allow for it, there's something wrong. Here's an embarrassing part of the story. At this point, we kind of gave up. We didn't think we could do anything else. And I had very hard conversations with Stephen. I then moved to the University of Utah to accept a tenure track position and kind of move on to a more academic life because these cases were exhausting me and killing me and depressing me. And my wife didn't want me to do it any longer. And I'm there, and Stephen writes to me and he says, I filed a habeas corpus petition on my own, pro se. And guess what? The judge is going to give us a hearing. Do you guys want to be involved? And like good legal vultures, we just swooped in. Of course, at that point, I'm in Utah, but I'm coordinating it with my colleague back in New York. We swooped in to handle the case because we actually got a hearing. But because of those limitations on habeas corpus that I mentioned earlier, innocence claims are not recognized. It has to be a constitutional or jurisdictional violation. We could not prove Stephen's innocence through that. He was freed in November 2007 on the grounds of ineffective assistance of counsel, a constitutional violation, because his trial lawyer, Barry, had failed to investigate this potential Anthony Guilfoyle angle, this other suspect. So Stephen was freed just a few months before he would have been free anyway for good time served in prison. He called me, somewhat happy, but he also said, I wish I had taken that plea deal. Here's what's happened over the intervening years. At this point, it's been 15 years almost. He got a job as a long-haul truck driver. And he called me once from Maine, where he'd tasted lobster for the first time and found it delicious. That was a great moment. But while he found that delicious, the taste of freedom was not very lucrative. He never received compensation for what happened to him because he hadn't been declared innocent. He couldn't prove that he was wrongfully convicted, which is a predicate for getting civil damages under the law. He has, to some extent, struggled ever since. He lives in an extended stay motel in New Jersey, which by definition is a sign of struggle, with his long-term partner, Lisa, and their dog, Christmas, a stray they found on the 25th of December a few years ago. I called him over the summer before my book came out just to like verify some of the facts. He'd given me permission to talk about the case, but there were things that I couldn't verify through public records that were just based on our conversations. And over the course of that chat, I asked him what I thought was an interesting question. Said, Stephen, upon reflection, what's the thing you most enjoy about your freedom? The thing you most treasure? Because I thought this could be my money shot at the end of the book, you know? I also cared, but I also thought like something great about like walking on the beaches of Southern Jersey with Lisa or playing fetch with Christmas, right? And he said something very peculiar. He said, my debit card. I thought this was peculiar because debit cards existed in 1999. And he said, well, my debit card gives me an alibi. I use it every 2 hours to buy a pack of gum or cigarettes or a soda. So if I ever get tagged for a crime I didn't commit, I can show them where I was. And that's not even the end. Over Veterans Day weekend, he called me again out of the blue. And he asked me for advice on a New Jersey lawyer. He's on the cusp of being evicted from his home in New Jersey. Here's an innocent man. Here's a man who never committed an act of violence, who spent 8 years in prison for a crime he didn't commit. He got the help of 2 law professors, 6 students who navigated these processes, maybe not as best as could be done, but far better than most. And we could not exonerate him despite years and years of litigation. What about the untold numbers of innocent people who are languishing in prisons across this country who don't have access to innocence projects, who don't have new evidence of a third-party suspect from a newspaper article? What about them? And one thing I like to do, and I do in this book, is I think those stories need to be told, they need to be heard, and we need to work together to somehow grapple with this problem. So I've gone on far too long, but I'd love in our remaining time to open things up for questions from all of you.
Oops.
Don't all rush. You know,
Okay.
there was that nice dog who looks a little bit like Christmas. We could get a...
Yeah, so showing on the screen is the I can't think of his name.
Oh yeah, there we go. It's Stephen. Here we go.
Stephen and Christmas.
There we go. That's
Yeah.
Stephen and Christmas. Yeah, there we go. Thank you, Neil, for showing that, and Amy. I lack the capacity to do it. But he's yeah. I love Christmas, and Stephen's. I really am very fond of him. You're not supposed to be, personally close with your clients, but after the litigation is over in these cases, you can't help but become friends, and I think, and that's okay. But it complicates the relationship when you have feelings of friendship for someone you're supposed to be objectively fighting for.
Yeah, sure.
Wow.
What do you see as the remedies, and what are the things that people who are not involved in the system can advocate for?
Well, thanks, Becky. So, here are some solutions, and I'm curious what you guys think. So in this book, and I've thought about this for many years, I advocate for both sort of micro level changes, tinkering with the processes, and macro level changes. So micro level changes would be things like, why shouldn't innocence be recognized in habeas corpus? Why not just expand the jurisdiction of a habeas corpus remedy? There's no real reason why we can't do that. We just should do that. Likewise, why should we have such a parsimonious, such a stingy vision of newly discovered evidence? Let's have a broader vision of it. Why should the direct appeal be so strict in giving deference to lower court decisions? Why not give appellate judges more autonomy to get a true fresh look at these trial decisions? So in the book, I advance a number of these, a friend of mine calls me at times an institutionalist, like inside baseball changes, like how could the process be a little bit more fair? But some of the macro level changes I suggest might be more fruitful. And Becky, this might go to your question, for non-lawyers, who people are, concerned with the political process, the legislative process, the lobbying process. So one is, there are three major ones. The first relates to the role of the American prosecutor. So the American prosecutors are district attorneys, and Needham's in Middlesex, right? It's Middlesex County?
Norfolk.
You're Norfolk. Okay, you're Norfolk County. That's right. So in Norfolk County, the district attorney represents the people of the Commonwealth of Massachusetts, represents the citizens of your county, not crime victims. When the DA pursues a criminal charge, let's say there is a crime in Needham, a crime in Brookline, when they pursue a criminal charge in Norfolk, they are representing the interests of the people, not the crime victim. And what that means is that they are ministers of justice who really should care equally with being a zealous advocate for the government's position and being fair to the accused. It's often said that prosecutors never lose a case as long as an outcome is fair. Whether it's an acquittal or a mistrial or a conviction, that's all a win, as long as justice was served. But that's not how the system works in reality. Prosecutors have elevated their advocacy role over their justice role, and they look at convictions and conviction rates as the coin of the realm. I heard of one prosecutor's office in Colorado that even gave cash bonuses to prosecutors who had high conviction rates after trial. Like, I call it a cash for convictions program. That's an egregious example, but I've heard of other sort of more subtle examples of offices that in the break room, they would have a list of prosecutors, almost like batting averages in the sports pages, with people at the highest performers with the highest conviction rates up here, low performers down here, or stickers, green ones for wins, red ones, the scarlet letter of acquittal, right? The A, scarlet A. So one thing I advocate for, Becky, is that prosecutors, to be ministers of justice, should set up internal conviction integrity units where they look into their own cases. And if they're worried about their own case, they can play a role in bringing it to the attention of the courts. Going back to my client's case, Stephen's case, my first effort after losing the appeal, after we assembled this new evidence, before I went back to this Judge Copertino, to ask for a hearing, was to approach my adversary, the prosecutor in the Suffolk County District Attorney's Office, to just get her, I'll call Annie, to agree to a hearing. I tried to appeal to her justice orientation. Annie, you guys would never want to convict an innocent person. If you think an innocent person is in prison, let's join together to have this open hearing so that the truth will prevail. She told me, I'll think about it. I need to talk to my supervisor. I'll get back to you. Never got back to me, never responded to my voicemails. The next time I saw her was in court before that Judge Copertino, where she argued against even having a hearing. So that's one thing you can do. I don't know Norfolk County if they have a conviction integrity unit. Middlesex has one, Suffolk has one, I believe Berkshire has one. I'm not sure about Norfolk. So that's one thing. Do they have an internal unit in the district attorney's office to look at these cases? The second suggestion is, why, given all the problems with these processes I've mentioned, why not create a new process? Why not have an independent agency, an Innocence Commission, a bipartisan commission that's created by the legislature? It's like an executive agency, you know, like the housing authority, whatever, that has funding and authorization to investigate claims of innocence. And if they find the claims to be independently credible, to refer those cases to courts for review with sort of a stamp of approval. This concept was first developed in 1995 in the UK. For some of you who saw the movie, oh my gosh, the Daniel Day-Lewis movie about the Guildford 4 bombing. Is anyone, My Left Foot, maybe? No, that was a different one, Daniel Day-Lewis. But after there were a couple IRA bombing cases, the Guildford 4 and the Birmingham 6 in the UK, where folks affiliated with the IRA were wrongfully convicted. And they were convicted based on, and Neil, you'll appreciate this as a scientist, apparently there was, the authorities said there was nitroglycerine found on their hands when they were apprehended on a ferry. But in fact, it wasn't nitroglycerin. It was a chemical compound that's found on playing cards, that they had been playing cards on the ferry, but yet they were wrongfully convicted of detonating 2 bombs in British pubs based on, you know, fraudulent science. And the UK set up an independent commission to do this. North Carolina is the only state in the US that does this. They set up an independent commission in 2006. And so far that commission has helped to free 15 innocent people. And the last macro level solution maybe is right in your wheelhouse as a faith-based organization, and a very progressive and thoughtful one, right? Which is eliciting empathy and creating empathy for our incarcerated population. So much of the conversation about criminal justice is about othering people behind bars. And oftentimes, even progressives on the left who want to do something about it, the language in the conversation smacks of sort of white saviorism, like, let's save these people. Well, instead of it being about saving people, let's just recognize that the line between Stephen Schultz and me is very, very thin. This is a guy, middle-class guy from Suffolk County who had a drug problem. He has a dog and a longtime partner, and he has a job, and he's just trying to make rent. He was wrongfully convicted. It could happen to anyone. He's a person. He's not just a number. He's not just a statistic. And working with people behind bars and advocating for people behind bars, giving them names and saying their names, that's something that we all can do and that you can do.
Yeah, Daniel, if I can interrupt, if you're done. First of all, I was an economist, not a.
Oh, I thought you were a scientist. Economist is a science.
Social science, but we'll give you that. Social science.
I knew you were good with numbers. Isn't that sciencey?
Yeah, sciencey. That's good. I mean, I taught a course in economics of crime for many, many years. And one of the things that I certainly emphasized as best as I could was the fact that money makes a difference.
Yes.
The income that an individual makes a big difference in defense. You were just arguing that we could all be victims. I mean, we could all be like your guy Stephen here.
Yes.
But the odds, the odds of us being in that situation are probably a whole lot less. But that goes to my point. Seems to me, if I really followed your story entirely, and I apologize if I didn't, the public defender in this case was the real issue.
Yes.
they do, how do they interact with the prosecution? Do they interact with prosecution? And to whose advantage do they interact with the prosecution?
Excellent. So a few thoughts on that, Neil, and that's a great question, and you understood it perfectly. As to your point, you're right. I was a little hyperbolic in overstating it to try to humanize it and make it relatable that this could happen to you and to your daughters and sons and loved ones. It probably couldn't, right? Because if you are zooming in to a lyceum at this hour, chances are you are a savvy, relatively sophisticated member of our life and world and would be able to better navigate the criminal justice system than Stephen did. And at least maybe pool resources from your congregation if you didn't have resources on your own to pay for a good lawyer. But it can happen in theory,
Sure.
and that the line is more permeable than one might think. But I agree with you. I definitely, in these, I like to overstate the likelihood to sort of motivate people. Now, as for your really astute observation, Neil, here's how it kind of works. So Barry Levine was a public defender, which means that he got paid by the state to represent poor clients who couldn't pay for a lawyer on their own. You could be an institutional public defender where you work for an agency. So I was an institutional public defender at the Legal Aid Society in New York before running that Innocence Project, and I got paid to handle cases, and I had the benefit of supervisors and an office to collaborate on cases with and get feedback. But a lot of public defenders are individual lawyers who take on individual cases to help pay the bills. Maybe because the institutional public defender doesn't have the bandwidth, or maybe there's a conflict of interest where an institutional defender is representing one co-defendant and the other co-defendant can't be represented by the same office. So it's assigned to one of these lawyers. So in New York, being one of these solo lawyers who picks up public defense cases, you're called an 18B lawyer. That's the name of the panel that supervises you, or not that gives you credentials. At the time of Barry Levine practicing, 18B lawyers got $25 an hour for out-of-court work and $40 an hour for in-court work. Now, for someone trying to sustain a private practice, so we're juggling private defense cases, wills, trusts, divorce law, contracts, real estate, that is not much. You could get $40 an hour for in-court work, which meant you were incentivized to file motions to get adjournments and to spend time in court, but you weren't incentivized to investigate. So one thing that we could do is we could just increase the budget and funding for out-of-court work of public defenders to incentivize investigations, because that's where, and Neil, I think you're 100% right, that's where this case could have been averted. If Stephen had had a lawyer who took the time 2 hours to meet with this waitress, the case would have probably been dropped. And I wouldn't be telling the story and I wouldn't know him, right? The other piece of this is, and it ties back to the deference that I talked about before, the standard for being deemed ineffective as a trial lawyer is very lawyer friendly. You have to show that the lawyer engaged in deficient performance and that deficiency affected the outcome. So basically, if there's a lot of evidence of guilt in the case, the court will say, hey, the defense lawyer did a few bad things, but the guy still would have been convicted anyway, kind of like no harm, no foul. There have been convictions where defense lawyers fell asleep during trial, used drugs during trial, were drunk during trial, and they were not deemed ineffective. In a famous capital case from Texas, the lawyer fell asleep off and on throughout the trial. And the defendant said, my life is on the line. I'm facing the death penalty. This guy fell asleep. I should get a new lawyer. And the judge famously says, the Constitution entitles you to a lawyer. The Constitution says nothing about that lawyer being awake. So let's change the standard for what effective assistance of counsel is. Let's not give lawyers a pass. Let's hold them up to a better standard of practice. If we're going to allow them to vindicate the interests of the accused, they should at least be up to the task at a minimal level. And by that, I mean awake, not on intoxicants, like basic stuff.
Where does that happen? Where's who would make that change in standard?
The change in the standard, Becky, it would be the Supreme Court, because which is not going to happen. But the Supreme Court, that decision, the test I gave you, showing a deficiency and that the deficiency affected the outcome, it comes from a 1984 case called Strickland versus Washington, a really notorious case of a death penalty case of a serial murderer in Miami who suffered from severe mental health issues, and his lawyer failed to present a lot of that evidence of his mental health at the sentencing phase. And so he was sentenced to death, when a lot of people thought that a decent lawyer would have been able to get him life in prison if it just put on, psychiatric evidence of his mental health condition. But it created this very, very deferential test for lawyers, which lawyers benefit from. So that would be up to the Supreme Court.
You think it makes any difference that Ketanji Brown Jackson is on there, and that her background is different from the typical Supreme Court justice?
It's a great point. I think it's wonderful that she's on the bench, a wonderful judge, the first public defender to be on the judge. She's going to add a really, really important perspective. The problem, as I'm sure you know from recent opinions, is just she doesn't have the numbers. You have such a strong coalition of conservatives. And what's interesting about political alignment and criminal justice is a little complicated, because the libertarian strain in conservatism sometimes manifests itself in defense-friendly decisions and sort of anti-government decisions. So my students, this drives them bonkers, but many of my progressive students can't stand the fact that I often will praise Justice Scalia's criminal procedure decisions, because he has a lot of criminal procedure decisions that are giving rights to defendants, suggesting that the government has to dot its I's and cross its T's, right? The government really in favor of allowing defendants the right to confront their accusers. And not always, he's inconsistent on it. He was a real advocate for the death penalty for historical reasons and things like that. But it's complicated in criminal justice. When it's social justice, we know it's not, right? Like we know how the affirmative action case is going to come down, and it's going to be, maybe Roberts, who knows exactly what it will do, but it's probably 6-3. But with a lot of these criminal justice things, we don't exactly know. But I think in this particular issue, it's not going to happen. But Ketanji Brown Jackson would be the one to write that opinion. I'm absolutely certain. Well, I shouldn't say. I imagine she was sympathetic to this. Yeah.
Daniel, is one of the reasons I can see, there's such a backlog in cases. I can see, people wanting to keep the status quo because we can't take on cases we've already dealt with. Why would we, it just seems like the whole system needs to be looked at. And
you're so right, Amy. I mean, so the problem is, resource-based, and it's also psychological, right? So the resource-based idea is we put all of our money and effort into the trial. And we do that based on a couple faulty assumptions, I think. The first is, how many of you have heard this? The American criminal justice system isn't perfect, but it's the best in the world. Without any support for that, like people say that all the time. And the idea is this belief that through a fierce, ferocious combat between two sides, the truth will prevail, that the adversary system leads to truth, that combat will produce truth. I think there's a lot of reason to think that an inquisitorial system, the phrase inquisition gets a bad rap because of 1492, but having an inquisitorial system where it's not adversarial, but it's just a quest for truth, could lead to more accurate results. Now, we're not going to necessarily get there, but I think that's part of the problem. We think the trial is everything. We put all of our resources there, and then everything else, as the Supreme Court said, the trial's the main event, the appeal is the undercard, sort of a sports analogy. It's not as important. The other reason, and Amy, you're onto this, there are so many psychological disincentives to looking at these cases objectively and with equanimity. I mean, we all know when you're really busy, allocating time to look back at a decision you've already made is just something you don't want to do. It's called confirmation bias, that once you've made a decision, there's been an outcome, you've developed a hypothesis or a theory. And Neil, this is probably something from economics you're familiar with. It takes a lot of contrary evidence to get you to depart from it. And Neil, this is more of the cognitive behavioral law and economic stuff, which you may or may not find at all compelling. A lot of people find it pretty specious, but there are these studies about how people will stick with their insurance plans at work, even though there are better options available, because they just don't want to look back at that decision. Or people who have decided that they are Budweiser drinkers and they take blind beer tasting tests, and it turns out that they vastly prefer Miller, will still stick with Bud. They're just convinced that there was a mistake, that their original decision is sort of locked in. And if you have that sort of cognitive commitment to your original decision, and you have so much other work that needs to be done, it reinforces it and makes it really powerful. And then related to that, just one last point on this, there's this strong aversion to cognitive dissonance. We all make decisions that harm people. We all make decisions that are bad decisions. If we looked in the mirror and acknowledged the pain that we'd caused to others, either inadvertently or consciously, we couldn't go on. Like, we couldn't wake up and keep going. So instead we discount it, right? The bad breakup with a girlfriend is not your fault. It was destined, or she can do better, right? Instead of taking ownership. And a lot of scholars call this an aversion to cognitive dissonance, that we have to construct a positive self-image. And if you're a prosecutor and you are learning that you or a colleague may have contributed to the conviction of an innocent person, it creates such dissonance between your self-image, your positive self-image, and the reality that you are not so great, that you just discount that information psychologically. I mean, this is why how many of our friends are defensive when you accuse, not even accuse them of something, but you even gently suggest a need for change or reform, and kind of the immediate reaction is to dig in their heels instead of actually taking an objective look and considering it. Part of that's cognitive dissonance. You were just averse to it. So lots of problems.
Yeah. Boy, it feels overwhelming when it's, how many, when you were working at the Second Look program, how many people, say in a year, said, I'm innocent, will you take my case?
Such a good question. So here's the myth and here's the reality. One myth that I often hear, and a lot of people believe, I think from TV shows, is that everyone in prison claims to be innocent. It's just what people do. Like, you walk around prison saying you're innocent, and it's really hard to differentiate the innocent from the guilty. That's a myth. The reality is there are lots of disincentives to saying you're innocent. The biggest one is, if you're in a state that allows you to get out on parole, you pretty much have to accept responsibility to get out on parole. If you say you're innocent at parole, the board is going to say you're in denial. There's a deeply wedded, you guys might find this interesting. It's both the origins of parole, I wrote a paper about this, they derive directly from Judeo-Christian principles of repentance. And that's why, in fact, during the 19th century, when parole arose, that's also when the term penitentiary arose to describe prisons. It's for penitence, people who are repenting for their sins. And parole was all about repentance. And once you've repented, you could be free, conditionally free. So if you're in prison, and most states have parole, you know that if you claim to be innocent, you will not be considered repentant by the board, and you'll have to stay in prison longer. So the actual rational incentives, if you're guilty, the rational incentive is to admit guilt, say that you're a changed person, do everything in prison not to get in trouble and to reform yourself, and get out as early as possible on parole. So in my experience, it's not as if everybody was writing me. I got lots of letters. I got tons and tons of letters, and it was monumental to go through it. But I think New York had something like 70,000 people in its state prisons at the time I was doing this. And I probably got 1,000 letters, maybe just, I don't even, it wasn't like I was getting 70,000 letters. And trust me, everyone in there knew about our program. Everyone knew about it. And many of those letters weren't innocents. They were people who were saying, the police did this, or, something went wrong in my case. So there were a lot of people claiming to be innocent, but not as many as you would think. And also, one of the worst parts about this in terms of work was you had to make these difficult decisions, right?
Yeah.
There were two of us. We had a revolving door of students. I did it for 4 years. And we could only really actively handle about 4 cases at a time.
Wow.
So I had a funny experience, and I'm sorry to ramble, but it's fun to tell some of these stories. I had a funny experience in the fall where a guy whose story I feature in my book, he was represented by a friend of mine. And I wanted him to come to my class to talk to my students, to Zoom in, because it was an amazing innocence case from New York, a guy wrongfully convicted of a gruesome rape, and he was freed by DNA like 35 years later. Like 30 years later, and the true suspect was known all along. There were so many leads pointing to the true perpetrator that were ignored. So I had this guy, Felipe Rodriguez. I reached out to him. I'm like, our mutual friend Nina said that I could reach out to you. I talk about you in my book. I would love for you to Zoom into the class. He was super gracious and said, I'd love to do it. And we became connected through Instagram. And then he sends me a picture of a letter I wrote to him in 2005, rejecting his case, 2003, rejecting his case. I had no recollection that I had ever heard of this guy before. My friend had freed him in 2017, and I had turned him down in 2003. And, I just said, Felipe, I'm sorry. And he was so gracious. He said, he was a very spiritual man. He said, it was a blessing because my lawyer who ultimately represented me is my best friend, and Nina is my hero, and I wouldn't have met her if you'd taken the case. And so it was a blessing. But yeah, like there are lots, and I've had other people, 2 or 3 other guys who were later declared innocent when we didn't take the case. And it's just, you make mistakes and you have to be decisive and you engage in triage, but a lot of it's resources and a lot of it's just the luck of the draw.
Is there anybody else out here in these pictures or non-pictures who wants to ask a question? I mean, so far it's only 3 of us who are visible to Daniel here. Isn't there anybody else who has a question? Is anybody else there?
Is anybody out there?
Well, Daniel, if nobody else is going to jump in, Becky, I'll get back to you in a second. I have another question if I could.
Yeah.
And actually, I took the opportunity of inviting you here. I also looked at your CV, and I'm interested in your paper that you did in 2021, Black Deaths Matter, the Race of Victim Effect and Capital Punishment.
Yeah.
I mean, I know when I taught the course, one of the things, of course, that seems to be very important, not only is the race of the victim, but the race of the offender. Now, is that really no longer the case? Has things changed? I mean, I based that on some older evidence and older papers than yours, but I'm just curious, has that changed in terms of
it hasn't
penalty?
Yeah, it hasn't changed that much, Neil, and I'm glad you taught that. I just tried to update some of the literature. And basically just to mention what Neil said, it's commonly understood that the race of the defendant is what really dictates or drives whether a prosecutor might seek the death penalty. Prosecutors, the capital punishment exists in 30 states, not in Massachusetts, but our federal government and 30 states have it, and it's always a choice. If somebody is convicted of a crime that's called death eligible, they could charge it as a capital crime or just charge it as first-degree murder, sentence of imprisonment. And in deciding who should get the death penalty or not, in cases that are death eligible, it's often a rule of thumb that the race of the defendant matters, that people of color who commit death eligible crimes are going to get the electric chair at a higher rate than white people. Like that's sort of an assumption. But when you look at the data, and I think, Neil, this comports with some of the data, David Baldus, and some of the information you probably cite, It's actually the race of the victim that is the biggest determinant in a much worse and more perverse way. And here's how it plays out. Prosecutors tend to value the lives of white victims more than Black victims.
Yeah.
And since most crimes are intraracial, most homicides, white people kill white people, Black people kill Black people. White defendants are actually sentenced to a death at a much higher rate than Black defendants, just because of a devaluation of Black victims, of the lives of Black victims. The prosecutors don't think that somebody who kills a Black person deserves death. But if someone kills a white person, they deserve death. And most people who kill white people are other white people.
Yeah,
but of course, the highest rate of the death penalty is Black perpetrators, white victims. It's rare because it doesn't happen all that often, despite movies and TV, but that's where the likelihood of getting the death penalty is the highest. So the data is really similar. It's sort of been updated in a couple states.
Okay, thanks.
Yeah. But my students always find that, and I don't know, Neil, you probably felt this too. They found it like, what? Wait, when I actually say white people get the death penalty at a higher rate than Black people, they're like, that can't be true. And then I say, well, here's why.
Yeah.
And then it's like, their hearts sank because it's so much worse, right?
Right.
By the way, I read recently that DeSantis wants to change the law in Florida so that the trial for the penalty for murder.
Oh yes, 10 jurors, right?
Yeah, it can be less than 100% of the juror. What do you think about that?
I think it's highly unlikely. I mean, it's interesting because there's a Supreme Court decision from a couple years ago, from 2020. Oregon and Louisiana had non-unanimous jury, just allowed you to be convicted based on 10-2 verdicts for the substantive crime, not death penalty, but just for guilt or innocence. And the Supreme Court said that's not fair; it should be unanimous. And that decision, it's called the Ramos decision, basically says going forward, states have to have unanimous juries. But what DeSantis is trying to do is not to tinker with what's called the guilt phase of a capital case.
Yeah, it's the punishment phase.
Yes, the punishment phase.
Right.
And technically, there could be a completely different calculation. Because there isn't necessarily this old tradition of jury unanimity on the sentencing phase, because to some extent, the sentencing phase in our modern trial is sort of an outgrowth of some changes in the 1970s that we made to capital cases. Right. So there isn't this sort of longstanding tradition of juror unanimity. So I'm really scared, Neil, that, he could do it.
Yeah.
And that this Supreme Court would let him do it.
Yeah.
I mean, can you imagine sentencing someone to death when there are two holdouts?
No.
Who are like, this guy should live?
Yeah.
Yeah, it could very well happen.
Yeah. Thank you, Daniel.
But no one's going to live in Florida, right? Everyone's going to leave.
Well, they're going to have to, because Florida will be underwater soon.
Exactly. Exactly. If
All
that
right.
happens, I will truly believe in God. So.
Becky, I cut you off. I apologize. So do you have another question?
Oh yeah. Well, just stemming from what you were just saying, is it, am I right in thinking that if you don't believe in the death penalty, you automatically can't get onto?
Yeah.
Is that national?
Yes. So basically, there are some Supreme Court decisions that say, if you say that you are morally opposed to the death penalty, you won't be what's called death qualified. At a minimum, everyone has to basically say they're open to it in theory. They're not, morally or universally opposed to it as a matter of principle. That they accept the idea that some people in certain circumstances deserve it, which is a real problem, because what it means is, like, if you look at the polls that say more than 50% of Americans believe that we shouldn't have capital punishment, it's creeping up. The innocence movement has helped with this. I can't remember, the last poll was something like 50. First time it was majority opposed, I think, 51, 52%. So you think basically, 52% of people are ineligible to serve. Who is going to serve? Only people who are either pro-death penalty or at least haven't made a decision. And if you haven't made a decision about the death penalty, I mean, I won't cast aspersions on people who are undecided. It might be because you've weighed the pros and cons and you can't come to a resolution, or it might be that you just haven't thought about it and you don't really care. So you're basically getting people who are hardliners or people who are agnostic and maybe don't care who are going to serve on the jury. And that's a problem.
It seems crazy to me. It
Crazy.
really does.
It's crazy. It would be, I would feel a little better about it if people who believed in the death penalty would are excluded too. That the only people, only people who could serve are people who were uncertain and would just look at it in the perspective, had no world view on it, whether that was because of ignorance or because of deep reflection. They had no universal view on it. They were just open to considering the facts and whether the facts met the standard in this particular case. I'd be a little more comfortable with it. But it's yet another reason among many why we just should get rid of the death penalty. Like we just,
Absolutely.
it's just, and in one of the, a really kind of, I don't know, ghoulish aspect of our work is many of us are trying to prove that an innocent person, 189 people have been freed from death row before being executed on the grounds of innocence, but we've been unable to prove through DNA yet that an innocent person was executed. In part because once someone is executed, the state gets rid of the evidence. But there's a case pending in Tennessee, and I talk about it in the conclusion of my book, where it could happen. It's currently pending. The Tennessee courts, it's a really strong case of innocence, a guy who was executed in 2006, and his daughter took over his estate as the personal representative, and she's suing for access to the evidence. And the Tennessee courts have said that because the Tennessee law gives a person a right to access the evidence, and she's not a person, she's a personal representative, she doesn't have standing to get the evidence.
Oh, come on.
Yeah, nope, I'm not lying. So far, she hasn't been allowed to get the evidence. But there's all this, there's evidence that the serial killer may have done it, who was in the area at the time, that her estranged boyfriend who was seen at the crime scene nearby may have done it. Like, there are two other suspects, and there's all this blood evidence and other evidence that has not been tested from this 1985 case.
Wow.
It's so galling. Like, why not just test it? Why not?
Pat Thal, are you still there? Because you seem like you wanted to ask a question.
Oh, I just thought that I should show my face because he's talking to all these people.
I shamed you. Oh, I'm sorry.
Pat, thank you very much.
Yeah. Well,
Anybody else? I'm not trying to avoid you, Becky, but
Absolutely. No. I'm just asking questions if nobody else is, but if
well, we probably ought to end soon anyway. Everybody wants to go listen to another speech or
Yeah.
speech tonight,
Equally depressing.
I suspect, by the way. All right. Did you have your last question, Becky? Would you like to?
Well, I was pretty interested. At a recent election cycle, there was a lot of talk in Massachusetts, it seemed like, to take another look at the role of the DA and to get DAs, to move some DAs along.
Yes.
And I just would like to get your thoughts on how effective that was. And is that something that's just in this state, or is that something a national movement? Because it seems like it could change the dynamic based on what you were saying, that if that role were different, it would really make a difference.
Becky, you're onto something really important, and I appreciate the question. So here's sort of the situation. Basically, since the murder of Michael Brown in Ferguson, which was back in Ferguson, Missouri, back in 2014, which is often considered to be not the beginning of the Black Lives Matter movement, but a really important early chapter. There's been a movement, it's called the Progressive Prosecution Movement, to get prosecutors in DA positions who are true ministers of justice, who aren't just tough on crime, but are open to the idea of innocence, who don't believe in mass incarceration, who are willing to decline to pursue charges that the police want them to pursue, who are willing to investigate police corruption. It's been a movement, and I'm a part of the movement, and it's nationwide, and it's been met with mixed results. So what's happened in a lot of places is you'll win the election, you'll get a progressive prosecutor in, but then there's blowback, and they won't get reelected. This
Oh.
happened in Berkshire County. Andrea Harrington was a progressive prosecutor in Berkshire County, and she got primaried out. She got on the
Oh.
wrong side of the police union and other people.
Mhm.
It happened in San Francisco famously, where Chesa Boudin, the son of one of the weathermen, Kathy Boudin, one of the 1970s lefty activists who was incarcerated for trying to kill a police officer. He's a former public defender who became the district attorney of San Francisco. It was a huge moment in the movement.
Wow.
He
Yeah.
was recalled. He was recalled about 18 months later. There was a petition in California to recall him. So Rachel Rollins here in Boston was a progressive prosecutor. She then became the U.S. attorney. But she faced some opposition while she was here, I think it's fair to say. This last election cycle, many people were optimistic about a challenger to the district attorney in Plymouth County, in Brockton, the Brockton area, who's quite conservative. The only Republican chief prosecutor in Massachusetts, a guy named Tim Cruz, who incidentally is the guy who today arraigned the Duxbury mom on those murder charges. And he's a longtime incumbent, considered to be quite conservative, quite tough on crime. And his challenger was a very progressive, former Boston prosecutor, a Black man who's also a reverend I can't remember he might be Presbyterian, named Rasan Hall, who used to work for the ACLU. And, some of us were kind of optimistic, right? He got trounced. Yeah, it wasn't even close. So, it's like, it's 2 steps forward, 1 step backward, this movement. Part of it is people don't pay attention to these races. I in my classes, I ask my students, it's kind of unfair of me to do this, but I do it as a random audit and also to kind of get them motivated. I just say, hey, do you know the name of the DA in the county where you live or where your parents live? And, if they live in Boston, they might know Rachel Rollins, but many of them don't know the name of her successor, who doesn't have as big a profile, Kevin Hayden. If they're in Middlesex County, they won't know. Norfolk County, I think it's Mike Morrissey, I don't even know. I don't live in Norfolk, but if people in law school don't know the name of their own DA, how can we expect the electorate, non-lawyers, to really pay attention? So there's this, huge uphill battle.
Leslie, did you have a question? Leslie, do you have a question? No, you wanted to show your face too? All right.
Thank you,
Just let me
Leslie.
unmute myself. No,
Oh,
I'm just,
Another Leslie. There are 2 Leslies on. Sorry, Leslie.
Oh, okay.
oh, Leslie, did you have one?
No,
No? Okay.
No. You're muted, Leslie Nelkin, by the way.
Jess, I really appreciate this talk. It's been fascinating.
Thank you, Leslie. I appreciate it. Thanks for coming.
Thank you.
All right,
Yeah.
Leslie Ross, go for it.
Oh, yeah. So, no, I just appreciated your last piece of advice about looking up the district attorney in our county. I think that's probably an
Yeah.
important thing to know. But I've also just been amazed at how little evidence factors into all these cases that
I
you're talking
know.
about. And some of it is just very clear cut evidence.
Yes.
And I just don't understand why there isn't a better vehicle for, presenting it, and how it can, how one person, could have so much power to
It's amazing.
disregard it,
It's amazing.
in terms of a person's, life and future and welfare and innocence versus guilt.
I know, it's amazing. And I wish I had a good answer for you, Leslie. I mean, I think part of it is the system is overwhelmed. That I often say this, and I believe it, and maybe this is a positive aspect. I think the system is not riddled with bad apples. I think the system is riddled with good people who are well-intentioned, but either lack the resources or the skills to do the job well. And you have good prosecutors who have tremendously high caseloads, who are getting pressure to close cases, who don't want to get on the wrong side of the police by declining to prosecute a case where there's been an arrest. And just, it's like a boulder that's rolling down the hill, that you can't really stop it. even though when the boulder starts to roll, it's not by choice. It's just because of the gravity, right? Or the nature of the slope. So I think that's a big piece of it. And I think part of the problem is, and this is why I think public education is so important, that we all tend to think exactly what, and I thought before becoming a lawyer, in law school, I believed this. There are so many people out there. There are so many lawyers. There are so many police, so many prosecutors that are checking up on everything, who are dotting their I's and crossing their T's, and every decision is being reviewed. And it's so hard for mistakes to be made. And then you see a case like Stephen Schultz, where the guy learns about his best defense from the friggin' newspaper. Reading, if he hadn't read Newsday even. I've often thought about that. Like, if he actually hadn't read the newspaper that day, he would have had no defense. There would have been no lead. There would have been nothing. We would have never thought to look, we wouldn't have been interested in the case because it wouldn't have seemed like a good innocence case. We would have never thought to look in Newsday for under the crime headings to look at similar robberies. Like, it wouldn't have happened.
Crazy,
right?
Yeah. I mean, even in like a retrial, wouldn't there be more weight on new evidence?
Yes. And Leslie, that's what's really important. So, what I didn't say, but it's really important to the whole narrative about Stephen's case is, yes, I was asking for an evidentiary hearing. And yes, if we got a hearing, maybe the judge would grant a new trial. But what I didn't say was that if the judge granted a new trial, that would basically be the end of the case, because prosecutors would probably not choose to try my client again, given that there was all this evidence pointing to Anthony Guilfoyle, right? So in a lot of these cases, you just try to get a new trial, and then the prosecutor declines to retry the person, and your person's free. So you're absolutely right. Like, sometimes prosecutors will retry these folks, and they do it again and again. Famous case actually from Plymouth County, Brockton, this guy, Darrell Jones, wrongfully convicted of a murder. And there's all this evidence suggesting he was innocent. He is freed under a Massachusetts procedure, a coram nobis type procedure. And then the Plymouth County prosecutors choose to retry him again. He doesn't take a plea to time served. He goes to trial and he's acquitted in 2 hours. Like, it was a waste of resources. It caused undue stress to him. It's just the prosecutors were so committed to their theory of guilt.
Wow.
Yeah.
It's the waste of resources. I mean,
I know.
Yeah.
I mean, does that must factor into, how much looking into these cases?
Huge. And also our biggest selling point, it's funny that sometimes I get outflanked by people on my left, because being an innocence advocate is actually a fairly centrist position, because there are a lot of people who are further left who will say, focusing on innocence is like a bipartisan issue. You can get Republicans and conservatives on board, but you're selling out, the poor, the marginalized, factually guilty people whose rights were violated and who are sent to cages for very minor infractions for long periods of time. And so in a lot of these cases, for innocence advocates, we definitely appeal to sort of the rational argument of like resource allocation. It costs $30,000 plus to incarcerate someone. So the state is paying money to incarcerate an innocent person. What about the cost of the guilty person being free? In a lot of these cases, of course, it's not just that you got the wrong guy, it's that you missed the right guy, and that right person goes on to commit more and more crimes. And so in my book, Stephen Schultz, it's not just that Anthony Guilfoyle was still going to prison for his plea deal, but in a lot of the cases I talk about, especially the DNA case, the DNA evidence will later, like 20, 30 years later, implicate the true suspect. And then I'll describe how during the intervening 20 years, that suspect committed 3 murders and 2 sexual assaults, right? Had the police done their job at the front end, had prosecutors done their job at the front end, not only would an innocent person not have spent all these years behind bars, but a guilty person wouldn't have been allowed to go free to perpetrate additional crimes. And that's an argument that even like the Koch brothers, there's a right on crime movement, it's called, a right on crime, a conservative movement that's like, it's just too expensive to get these things wrong. Yeah. So there are lots of different levers that people are pulling.
Well, thank you for,
Oh,
I could talk all night, as you guys know. Neil, you're gonna have to turn me off. So.
You are going to be competing with Biden very soon.
Oh my gosh, it's 2 minutes out. I'll let you go. You guys are too polite. I lost track
Thank
of
you
time.
so much.
Thanks.
It has just been just a fascinating evening.
I had a great time. Thank you
Thank
all
you.
so much.
Thank
I hope to
you.
stay in touch.